Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for tuning in. First on the docket, Lori Vallow's attorney seeks yet another delay. A nurse has some serious legal issues. A man renovating his house gets a big surprise in the basement. This is why the cops always want to look in your trunk, and our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for watching. I know some people don't like it when I ask, but if you haven't already done so, we would ask you please subscribe. Hit that little bell so you receive a notification, and as always, leave us a comment. First on the docket, Lori Vallow. Well, as we know, Miss Lori Vallow is seeking her third bond reduction hearing on May 1st. It has been continued twice now because of the COVID-19 virus. Well, that hearing is still a go as of right now. So by 2 p.m. Friday, we should have an idea as to whether Ms. Vallow will be getting a bond reduction and maybe going home to her loving husband, who will probably greet her with open arms. But her attorney, this Mr. Means character in the Lori Vallow case, has filed a motion to continue the preliminary hearing. That was originally set for May 7th and 8th, and the district attorney is not objecting. In fact, it was a stipulated request to continue the preliminary hearing. This case is not that complex as it relates to the child desertion charges. The district attorney would simply have to put the investigating officer on the stand, and for lack of a better term, he would regurgitate what he put in the affidavit for an arrest warrant, and the judge would find probable cause. This would be the opportunity for the defense attorney to basically say, give me your theory about the case. Why do you think these children are missing? How do you know they haven't just run away? Who knows, for whatever reason? How do you know they weren't kidnapped? You never know. The defense attorney would ask those types of questions. But in the meantime, this attorney is making all sorts of requests that frankly just don't seem that relevant to me at this time. As you may recall, we talked about it a couple of weeks ago. He filed a litany of motions and a ton of subpoenas to various organizations requesting emails of various witnesses in this particular case. Mr. Means filed basically a renewed request for discovery, requesting all the documents, records, messages, emails, communications, calendars, text messages, computer, electronic, forensically obtained documents, related and confiscated devices of Mrs. Melanie Pawlowski, formerly known as Miss Melanie Bordeaux, Mr. Ian Pawlowski, and Mr. Brandon Bordeaux. And he goes through and makes the same requests, and he requests all records relating to the telephone call that the sheriff has already acknowledged was recorded but deleted, which was an attorney-client call. Let's face it, or Mr. Means should face it, his attorney call being destroyed, although it'll be rather interesting to see why it happened, why the mistake was made, who may have listened to it, it has no relevance to the actual charges here whatsoever. And as we have discussed before, why this is a somewhat wild goose chase is at the end of the motion that he filed, and he states, pursuant to Rule 16 of the Idaho Criminal Rules, this request relates to information in the possession or control of members of the prosecuting attorney's staff and to others who have participated in the investigation or evaluation of the case who either regularly report to or with reference to this particular case have reported to the office of the prosecuting attorney. Bam. Okay. A lot of these emails were not, or probably are not, in the possession of the district attorney's office. Unless they were specifically requested and or obtained by the prosecuting attorney, then they would have to be turned over. already in discovery. You don't have to necessarily request this formal request because discovery is always ongoing and it's self-executing. The defense shouldn't have to ask for it. If there's an ongoing investigation, as we know, the Attorney General is looking into matters related to the death of Tammy Daybell, then those wouldn't have to be turned over as long as it's an ongoing investigation. She hasn't been charged yet. And there's nothing to indicate that it would be relevant to this particular case. So I'm not sure why he is trying to create a whole lot more work for himself for information that is not relevant to this particular case. The district attorney has previously objected to these requests because they say we don't have it. It's not within our care, custody, and control. And no one that reports directly to us has those documents either. If we had them, they were already turned over into the discovery and turned over to the defense. So not sure why this attorney keeps going this generic route. If he thinks there's something in particular, he should just ask for it. And he should subpoena the person that would actually have it or potentially have it. That would be the people that he lists in the motion who he's asking possession of that. That would be me asking to turn over all the relevant emails that Kyle, our trusty producer, might have, but yet asking you as a member of the YouTube audience to produce them. It's impossible. You wouldn't have to. It would be burdensome. You just couldn't do it. Not sure where this guy is going. We've said it before, and I'm giving him the benefit of the doubt, just like all the people that we discuss here are presumed innocent of the charges against them. The attorneys are presumed competent. We've looked at his website. This man practices primarily personal injury work, mediation, and family law. Doesn't even reference criminal defense work at all. Normally, if people do criminal defense work, they say, this is what I do. And this is not the kind of case you want somebody that doesn't have that kind of experience handling the case, because from a court's perspective, the judge is going to look at it and say, I've got a guy who's probably not potentially competent as it relates to a particular area of law, and I could have this case reversed if there's a conviction if she receives ineffective assistance of counsel. Now, every criminal defendant is entitled to counsel of their choice as long as they're paying for them, and it's their call. But it just seems like this is already turning into a huge cluster. It's not that complicated. And guess what? When I know my client's going to be vindicated, I don't seek delay. I move forward. Charge, charge, charge. Not sure what this guy's doing. Next on the docket, a Minnesota nurse is in some big trouble and has some legal issues coming her way. Kelly Jo Anderson is 35, and she lives in Barnesville, Minnesota. She's a nurse, and she apparently was considering adopting a child with her husband. They were caring for this child. Now, it is alleged that Miss Anderson brought the child into the emergency room. It was blue and lifeless and had head and facial wounds and bruising. Miss Anderson did not have much of an explanation for the bruising and wounds to the head of the unidentified child. However, she stated that the child was in the bathtub, and then the child threw himself several times from the bathtub to the toilet, obviously looking to see if there was some sort of medical issue that could explain the cause of these injuries, perhaps considering seizures. Asked the husband, the potential adopter with Kelly Jo Anderson, that's the husband, Kyle Anderson, whether he had ever seen the child experiencing seizures. He was not aware of the child either being diagnosed previously with seizures or had witnessed a seizure himself with the child. Now, the husband is not charged, and it would appear that the nurse, Kelly Jo Anderson, has some splaining to do. She is facing charges of second-degree murder, which carry up to 40 years in prison. Next on the docket, a man renovating his house gets a big surprise. So the man that's renovating this house is actually a mayor in Bowling Green, Kentucky. and he was apparently renovating this house that he's working on, and he heard some noise and smelled the smell of cigarettes down by a crawl space. When he got there to the crawl space, he didn't see much of anything. However, he noticed that there was a bag with some women's clothes, as well as some blood on one of the entrances to the basement. The mayor, Bruce Wilkinson, not thinking much of it, but just kind of chalked it up to weird circumstances, went back to work. He had to go back downstairs a second time because the circuit breaker popped, and he went down there to reset it, whereupon he found a woman with brunette hair in her 20s in the basement. She apparently looked scared and frazzled and said that she was hiding from someone and then ultimately took off out the door. The mayor, Mr. Wilkinson, was also a former police officer with Bowling Green for many years, and so he called the police immediately to report this. No one was arrested because they don't know where this young woman went. Hopefully she's okay, but this provides a good example to explain the difference of what is commonly referred to as burglary as opposed to a criminal trespass. All right? A criminal trespass is if you enter a property without permission or you refuse to leave the property after that permission has been revoked. So, for example, if I go to a party and the owner of the house says, "Scott, you need to leave," and I say, "No, I'm staying here," I am committing a criminal trespass. If I entered the property without an invitation, that too is a criminal trespass. That could be a misdemeanor or a felony. What gets you into the big time realm is a burglary. A burglary is when you enter the dwelling of another, could be a house, could be a business, could be an outbuilding, and that you have the intent when you cross the threshold of that house to go in there and commit a crime. It can be any crime. You could go in there to assault somebody. You could go in with the intent to steal something. That is what makes it a burglary versus a simple criminal trespass. It would appear in this particular case, in the home of Mayor Bruce Wilkinson, that the woman was probably criminally trespassing, thinking that the house was abandoned since he was renovating it, and decided to stay there without permission. She would ultimately be arrested, but as we've talked about before, you have a potential defense of duress, that you were in danger and you stayed there immediately to prevent any greater harm from taking place. But when that harm has ceased, then you have to basically go away and apologize and pay for any damages. Probably not going to work here since this young woman fled away. So you can't make this stuff up, ladies and gentlemen. It happens every day. Just when you think you've heard it all, somebody comes up with a new set of scenarios and you think, wow, who would have thought to have done that? Next on the docket, have you ever wondered why the police always want to search your vehicle, particularly if they think you're up to no good? Well, this is the reason why. An individual by the name of Lance Gordon, and he's obviously presumed innocent, he's a 32-year-old man. He was pulled over for speeding by the North Carolina State Troopers. And when they made their initial contact, they asked for the cursory license, registration, etc. The officer noted that the vehicle was not registered in the name of Mr. Gordon, and the officer became somewhat suspicious. Well, the officer wasn't able to conduct a thorough investigation at that time, so they arrested Mr. Gordon, who had an outstanding warrant, and they towed the vehicle and put it in impound. The police officer wanted to do some further investigation and speak with the rightful owner of the vehicle, a woman by the name of Angela Lee. The police were ultimately unable to get a touch with Miss Lee because apparently she was simply not available. So the police officers, doing some good police work in this particular case, didn't just go down to the impound lot and search the vehicle, saying, "Oh, we're searching it for impound reasons. We're protecting the property of the defendant." No, they towed it. They did a quick little inventory search. They didn't search the entire vehicle until they obtained a warrant. That's right, ladies and gentlemen. The police cannot just go through your property without obtaining a warrant unless somebody, a rightful owner, or someone who has a possessory interest in that vehicle, gives consent. Now, obviously, Miss Lee couldn't give consent, so for the police to search the vehicle, they had to get a warrant. Mr. Lance Gordon had a possessory interest in the vehicle, so if he wasn't going to give consent, they would have to get a search warrant as well. Well, when the police officers obtained the warrant and they opened the back of the trunk, guess who they found? That's right, Miss Lee. And the significance of this is that had the police simply gone there, searched the vehicle just as a, check things out, so to speak, and opened the trunk and found the body of Miss Lee, that evidence more than likely would have been suppressed as an illegal search and seizure, and the body, the evidence of a deceased person, would never come forward in the case of Mr. Lance Gordon that is forthcoming, and more than likely he never would have been charged, or if charged, the prosecution would not have had any evidence to present as it relates to her death. So, good police work to the North Carolina State Highway Patrol. Next on the docket, our dumb criminal contestant of the day. And let me just clarify, ladies and gentlemen, we call it the dumb criminal of the day, but we're not making fun necessarily of the individuals that are committing the act. And frankly, you probably won't find anyone that has more empathy and compassion for a lot of these people, because a lot of times, as you've noticed, there have been drugs and alcohol involved, and they make a lot of poor decisions with being under the influence of both of those substances. But what we're talking about and what we're highlighting is their acts. Now, here today, we have a man directly from the state of Colorado, and I've got a feeling we may want to track him down. Our contestant today is David Pangallo. He resides here in the state of Colorado, and he is our dumb criminal contestant of the day. Now, like I said, we're not insulting him, but what he did was pretty stupid. So Mr. David Pangallo goes to his local bank, can't go inside because all the banks are closed here because of stay-at-home orders, and so he had to go through the drive-thru. And as he's putting the deposit into the drive-thru, putting items in the little tube, sending it off to the teller receives it, opens the little tube, finds the cash deposit of Mr. Pangallo, and also notices the 2 bags of containing a white powdery substance, suspected cocaine. That's right, he was trying to deposit his drugs at the bank. Now, to Mr. Pangallo's credit, he apparently spoke with the police and admitted that he did not intend to deposit the drugs. It must have been a mistake. Probably some more of that good decision making when one is under the influence of a controlled substance. And this is another teachable moment. Now, one would say, well, what could Mr. Pangallo be charged with here? Could he be charged with distribution of a Schedule II controlled substance? Yes. Could he be charged with possession with intent to distribute? Yes. And third, maybe just a good old-fashioned possession of a controlled substance. A, B, or C? Well, or D, all of the above. If you chose D, all of the above, you are, in fact, correct. Mr. Pangallo could be charged with distribution, because if you give a controlled substance, i.e. drugs, to an individual, even if they don't give you any money, it's illegal to do so. That's distribution. If you possess, and you possess a large enough amount, and you have the intent to distribute, or it can be inferred that there's intent to distribute, like it's more than, recreational use, you can be convicted of that as well, and ultimately possession of a controlled substance as well. District attorney would more than likely charge all 3 of those counts, and even if you went to trial and lost on all 3, they would merge, but it would be the most serious count that he would be sentenced upon. Thanks for watching. We appreciate you taking the time. We know there's lots of things that you can be doing these days. We know there's lots of things on YouTube and everywhere else that you could be watching. So the mere fact that you take the time to watch our channel is greatly appreciated. It does not go unnoticed, and we are humbled by that. Thank you very much. Have a great day.